In this video, we take a look at the latest XRP news. Will XRP be able to fly to the moon? Right answer. Elon Musk, the CEO of world-renowned creative firms such as Tesla, SpaceX, X, and others, has released a new X post on his personal account, which has sparked a spirited reaction from the X community. The SHIB and XRP armies were among the first to display their excitement. Someone in the comment thread said that this was yet another cryptic X post from the world's richest entrepreneur. This time, Elon Musk tweeted a preposition and two letters, in XSS. As usual, XRP supporters compared the X to the XRP emblem. The Shiba Inu army's response was especially amusing this time, as they compared the ES to SHIB. Vet Kusama, a member of the SHIB team, wrote, in XSHI. SHI is a stablecoin under development by the Shiba Inu team, and it will be utilized in the SHIB ecosystem with other tokens such as SHIB, Bone, Leash, and Treat. Along with SHI, the latter is yet to be constructed. Many people commented on Musk's new tweet, each with their own interpretation. According to one critic, the meaning of in XS is most likely in excess. That didn't clarify what Musk was talking about. The blogger discusses XRP in the video provided by that account, referring to it as Ripple's XRP. Deaton informed the community that XRP is not a Ripple native currency. These disputes were put to rest roughly 5 years ago when the San Francisco-based blockchain corporation Ripple Labs announced that it had obtained the whole XRP supply from the XRP Ledger founder. One of them was David Schwartz, the current Ripple Chief Technical Officer. According to that assertion, Ripple did not establish XRP. Deaton said on Twitter that it will be cool when XRP is only referenced as XRP, rather than Ripple's XRP. He revealed that the financial giant does possess a significant quantity of XRP, but it is currently less than 50. He also said that he does not think Ripple had any involvement with the announcement made in the aforementioned video message in the tweet. He also expressed optimism that one day bloggers would get it straight and stop talking about Ripple's XRP and start talking about XRP and XRP holders. Another interesting aspect of the disputed tweet is that the blogger indicated that mobile phone game creator Roblox announced the incorporation of XRP into its payment system. Roblox has around 200 million active monthly users. According to the video blogger, they spent a whopping $700 million on in-game purchases in the first 3 months of this year. The story was circulated by many media sites as a result of a tweet released by BitPay. The tweet was just released by BitPay, a cryptocurrency payment processor, and Xsola, a firm that organizes in-game payments on Roblox. However, according to individuals close to the situation, BitPay confessed that the XRP integration by Roblox was a mistake. The tweet was taken down. As speculation about Ripple's prospective initial public offering, IPO, grows, the cryptosphere has been filled with it, notably from key players in the XRP community. One such hypothesis, offered by notable XRP influencer Reth Afkaneman, Wook, delves into how Ripple could restructure its activities post-IPO, particularly with regard to its famous cryptocurrency, XRP. According to Wook, if Ripple goes forward with its IPO, the company may route its cross-border payment activities via one or more different subsidiary businesses. According to Wook, such a strategic change might greatly reduce the complexities of payment licensing. The overall justification for this move is Ripple's planned capacity to smoothly enter new markets, facilitate partnerships with partner businesses, and thereby streamline regulatory approvals. The predicted ripple effect, pun intended, on XRP is a fascinating aspect of Wook's hypothesis. Ripple may carve out a more unique identity for XRP by transferring cross-border payments into autonomous companies after the IPO, slightly distancing it from the flagship Ripple brand. This anticipated structural reorientation would be more than just a cosmetic brand change. It might mark XRP's transformation into a completely independent entity, focusing intensely on perfecting its payment capabilities. Furthermore, Wook has investigated the prospect of Ripple locating its business outside of the United States. A relocation of this size might be enticed by the attractive tax benefits associated with worldwide registration. Concurrently, newly established Ripple offshoots may have the authority to take over smaller remittance companies without the explicit consent of Ripple's principal shareholder base. Predictably, Woke's hypotheses have struck a chord with XYRP enthusiasts, sparking lively debate about the potential implications for both Ripple and XRP. Desert Capital's creator, Yasin Mobarak, agreed with Woke's viewpoint. Another enthusiast, on the other hand, proposed completely renaming XRP to get it out of Ripple's shadow, a proposal received with Woke's cautious skepticism, labeling it possibly structurally complex. Furthermore, there's persistent discussion as to whether Ripplex will stay at the company's primary operating helm or be absorbed into the planned payment subsidiary arrangement. To be honest, these discussions, however insightful they may be, are based on conjecture and may not fully capture the final course Ripple and XRP may take. To put things in perspective, Ripple was mired in a legal nightmare in 2020 when the Securities and Exchange Commission, SEC, hit it with a $3 billion lawsuit. The regulatory agency said that Ripple deceived its investors and illegally sold unregistered securities, namely XRP. In July, a federal district court said in a complex finding that automated sales of XRP to ordinary investors did not fall under the securities category. Nonetheless, the court recognized that contracts totaling $728 million meant for institutional sales were, in fact, unregistered securities transactions. Surprisingly, both the investing community and Ripple Labs viewed this decision positively. Since X was Twitter, Ripple's struggle with the SEC has attracted headlines and sparked discussion. The original ruling of Judge Torres was eagerly anticipated, and possibly the most significant element of her opinion held that the sale of the XRP digital token on public exchanges did not violate federal securities laws since purchasers had no reasonable expectation of profit based on Ripple's efforts. The SEC, on the other hand, is nothing if not relentless. An interlocutory appeal is one that occurs while other aspects of a case are still being heard. Those who recall Judge Torres' previous judgment may recall that this case is slated to go to trial on April 23, 2024. In this case, however, the SEC filed a petition asking permission to appeal Torres' conclusions about programmatic XRP sales and other distributions of XRP as payment for services. According to the SEC, this prospective appeal would be significant in a large number of litigation. However, Judge Torres rejected the agency once again, stating that the SEC had failed to fulfill its burden of demonstrating that there were significant issues of law or that substantial grounds for disagreement existed. Although crypto proponents celebrated Judge Torres' first judgment, as well as her denial of an interlocutory appeal, this dispute is far from ended. After the April 23 trial, the SEC may appeal the whole verdict, something Ripple and XRP investors would certainly like to avoid even if a favorable judgment from a federal court of appeals is in Ripple's future. If the SEC requested and was given permission to appeal the whole case, it might be many years before Ripple and the industry as a whole obtain the clarification they need, and that is assuming Ripple wins again. That is a significant if, given that Judge Torres' earlier judgment was not a full success for Ripple. As we mentioned in our earlier piece on this matter, Judge Torres determined that Ripple violated federal securities laws by selling XRP to institutional investors. Furthermore, other courts may refuse to adopt Judge Torres' decision, whether because they disagree with her interpretation of federal securities law or because it is inapplicable to a different factual context. Consider the ruling of Judge Jed Rakoff in the SEC's action against Terraform Labs. Judge Rakoff ruled there that the SEC had a plausible claim that Terraform Labs' TerrUse token constituted a security when offered on public exchanges. However, keep in mind that Judge Rakoff made his ruling while considering Terraform's move to dismiss the SEC's action. This implies that when deciding the case on the merits, Judge Rakoff was obligated to accept all reasonable conclusions in favor of the SEC. For the time being, Ripple and the SEC will continue to prepare for their April trial, while cryptocurrency remains in regulatory limbo. Other courts may soon accept portions of Judge Torres' July 13 judgment as governing precedent, but since Congress has yet to create a complete crypto statute, it is more necessary than ever to consult with legal specialists knowledgeable with digital assets. Early consultation with Kelman PLC's attorneys is the most effective approach to assure compliance with possibly relevant laws and regulations, as well as prevent legal hazards and fees that may otherwise harm your organization.